Is it possible today to protect cash by opening up an offshore bank account? Well, the answer is it used to be, but it is no more. Now, many years ago, you would read about people who have accounts in Switzerland or Liechtenstein, and where those accounts were protected because no U.S. creditor or court could even access the existence of the account or the amount in the account because of the bank secrecy laws that existed in Switzerland or these other EU countries. Today they have such laws, some laws in the Middle East countries, and people would set up, readily walk into these accounts, put unlimited amounts of money, and then the accounts would not be discoverable. That type of technique no longer exists today because in previous years the U.S. authorities and government have entered into treaties with these foreign countries that have required the banks to disclose the existence of foreign accounts. Secondly, not only the existence but the amounts. And secondly, that the foreign banks, because of past experiences, adverse experiences with U.S. authorities, have made it much more difficult, if not impossible, for a U.S. person to, by themselves, open up a bank account in another country, in their own country. And because of that, the countries where foreign accounts are available have been dwindled to a few countries in the Middle East and also a few countries in the Far East, countries like Hong Kong, for example. Secondly, even then, if you are able to make the connection to open up and find these banks and open up the accounts, doing so is expensive. There are substantial fees involved or imposed on U.S. persons opening accounts in the select dwindling amount of foreign countries. And there are substantial ongoing fees for transactions in these accounts. We find, I think most other practitioners have found, that the only effective way today, cost-effective way, to have foreign bank accounts is through a Cook Islands trust, an asset protection trust, because the offshore trustee can freely open accounts in favorable jurisdictions in the EU, Switzerland, similar countries in the EU that have good banking establishments. And the trustee is not going to be hit with the kind of fees that a U.S. person would be subject to, and is not subject to the same reporting treaties that are imposed between the U.S. governments and these foreign banks. So it is much easier for a foreign-based Cook Islands trustee to open accounts. You then, as the client, could transfer funds to the trust and then have the trust open a trust account on your behalf. So effectively, you're having the offshore account, but you're doing so indirectly through the establishment of asset protection trust.